In this session, we're going to cover a real property multiple choice question together. So go ahead and pause the video, read the question, pick your answer choice, and then we'll talk about the correct answer. So the correct answer in this case is A. And the reason for this is that the sister and brother own the land as joint tenants. The rule is joint tenants have a right of survivorship. So that means if one joint tenant dies, the other takes over their interest. Their interest spreads like smoke, okay? The tenant that died cannot will away their interest. They can't give it away after death, okay? The other joint tenant owns the interest completely free and clear from any interests of the other joint tenant. All right, so here the brother is the true owner of the whole property. The only thing that the sister could have done during her lifetime would be to change the joint tenancy into a tenancy in common. A tenancy in common does not have a right of survivorship, so if that were the case, they would each own 50%, and when she died, it would go to her heirs or whoever she leaves it to in her will, and the creditor would still have an interest. So did she turn it into a tenancy in common? There's 4 ways to do that, and we use the mnemonic GSAM, which stands for give it away, sign a contract of sale, actual judicial sale by a creditor, and grant a mortgage in a title theory state. Here, none of these were met. She didn't give it away, there was no signed contract of sale, there was no actual sale by the creditor did not foreclose during the sister's lifetime, and there's no indication that that there was any mortgage given in a title theory state. So basically, because they were still joint tenants when they died, her interest disappeared. The brother owns the property free and clear because when the sister's interest died, the creditor's lien on her interest also disappeared with her interest.